Aloha, I'm Leo Asuncion, Acting Director of the State of Hawaii Office of Planning. I'd like to invite you to add your voice to an important discussion on Hawaii's land use system. The state land use system is important because it defines how Hawaii's lands are designated and used as agricultural, urban, conservation, or rural lands. Since the state land use law was established in 1961, much has changed. Our aim is to produce a report that examines our land use system's effectiveness and to ensure the system meets Hawaii's current and future needs. Later in this program, you will learn about the land use system, the review project, and how the draft report for the project was developed. I encourage you to visit our website, review the draft report, and send us your comments and suggestions by May 31st. Mahalo.
Well, the current Land Use Commission, or the current Land Use Entitlement review process and the role of the Land Use Commission is very important with regards to preserving our agricultural and conservation lands. The length of the process, we feel, has impacted the amount of housing that has come onto the market and impacting the price and families that are trying to get into housing. So the change that we would want to see is to reduce the length of the process by possibly incorporating the review of both the State Land Use Commission along with the counties and or the city. A lot of the requirements on these projects that go before the Land Use Commission are redundant. They can be done primarily at the county, but of course we would need the input of the state to have, in order to preserve the agricultural and conservation lands. But our concern is the length of time and in order to get more housing to our residents of Hawaii. It's very important to get involved because the land use entitlement process, of course, impacts the future of our state with regards to preserving the lands that we need to preserve and our natural resources, and the housing situation of our state, to get more housing out for our people and for families. And we want our kids to come back and stay and be able to live just like their parents and grandparents have done before.
Hello, my name is George Ata. I'm the Director of Planning and Permitting for the City and County of Honolulu. And with regards to the topic that we're discussing, the State Land Use Law and the Land Use Commission's role, I think the law has been very good actually for Hawaii, and although it has had its problems, and all the complaints about the length of time it takes, I think, are valid, and the repetition that the applicant goes through the process in order to get his entitlements are valid, I think, criticisms. But I think as a whole, the system is the only integrated statewide land use planning system in the country, and I think the intention of protecting our natural resources and making sure that there's an appropriate allocation of land supply for the varying functional uses of the land is a good idea. I think the problem that I see as I've watched this process evolve over many decades is that over time the process has become more, the boundary amendment process has become project specific. And so the Commission then focuses on boundary amendment based on individual projects. And while this may be the convenient and easy way to make those decisions, I think it skews what the real intent of the system is, which is to have a proper allocation of land supply for the appropriate uses and for the betterment of the community. And if you make those decisions on a project-by-project basis, you don't really do foreplanning. Basically, the Commission is in a reactive mode trying to address and mitigate impacts from the project. So I think one way to improve the system is for the Commission to be more proactive in a planning role and actually consider boundary amendments independent of projects, and and then make those decisions that way. And I think some of the controversy that is involved with land use decisions will change if it does it this way. Admittedly, it's a harder process because you would then have to justify boundary amendments based on projected planning principles and state values. But I think in the long run, it's a better way. And I think that way the Commission can then focus on state interests as opposed to city and county interests. And so there will be a proper separation of issues as to what's considered at the Land Use Commission and what's considered during the county entitlement process. And I think that would be a good and clear separation of the functions, so we would avoid the redundancy, and which is one of those criticisms. But overall, I think the system should be reformed and not abolished.
This presentation provides background on the state land use law and the broader statewide land use system to provide a context for the state land use review undertaken by the State Office of Planning. A draft report on the project's findings has been released for public review and comments. The Office of Planning is the state's planning agency, which is responsible for statewide comprehensive and regional planning, including participating in the state land use decision-making process. Through this planning role, the Office of Planning has an interest in ensuring that the state land use law is achieving its purpose, which is to preserve, protect, and encourage the development of the lands in the state for those uses to which they are best suited for the public welfare. In OP's work over the years, concerns have been raised about the land use law and the broader land use system. Some feel the process set out in the land use law works fine. Others feel it is duplicative and does not result in good planning. The purpose of this review was to examine how well is the system working and how might it be improved. The State Land Use Law, Chapter 205, Hawaii Revised Statutes, was enacted in 1961 in response to scattered subdivisions without adequate services, development on limited prime agricultural lands, unprecedented population and economic growth, real estate speculation, and calls for a greater state role in land use. The state land use law, as codified in Chapter 205, provides a framework for state land use management. First, it establishes 4 state land use districts in which all lands in the state are classified: urban, rural, agricultural, and conservation. Permissible uses for the districts are broadly defined in the law. Land use in the urban, rural, and agricultural districts are regulated by the counties. Changes in district boundaries are administered by the State Land Use Commission, and counties have authority to redistrict parcels in the urban, rural, and agricultural districts for parcels that are less than 15 acres. The State Land Use Law is administered by the State Land Use Commission. The Land Use Commission is comprised of 9 members who serve voluntarily, and they are supported by an LUC staff. Members are appointed by the governor and confirmed by the State Senate. The LUC's primary decision-making responsibilities include amendments to state land use district boundaries, special permits on lands more than 15 acres for unusual and reasonable uses in agricultural and rural districts, designation of important agricultural lands pursuant to the state constitutional mandate to preserve and protect the state's agricultural lands, and declaratory rulings to clarify terms and applicability of the state land use law. Finally, the law provides for the counties to enforce uses in the urban, rural, and agricultural districts. Since the law's enactment in 1961, the law has been amended many times, but the basic structure and roles have remained basically unchanged. Key changes to the law include, in 1975, following a Supreme Court ruling, all petitions are required to be heard by contested case procedures, a court-like process. Prior to that, the LUC held hearings and voted on boundary amendments like other legislative type hearings. In 1995, the law was amended to require the LUC to decide on district boundary amendments within 365 days. And most recently, in 2005, the law was amended to set standards and criteria and procedures for the designation of important agricultural lands. The statewide land use system includes a state planning and permitting component. State planning includes a statewide planning framework set out in the Hawaii State Plan, as well as various functional plans to carry out the state plan. State land use management occurs through the state land use law and through conservation district use approvals by the Department of Land and Natural Resources. There are also state agency plans. These could be long-range and program plans or capital improvement plans, as well as state agency permits involving environmental permits or facility permits. The state land use decision-making process is one of many elements in the development process, including the land use district boundary amendment process. The entire project approval process of state and county permits and approvals could take anywhere from 7 to 10 years. The blue-colored bars are areas where the state is involved in the project approval process if a project requires a district boundary amendment. The district boundary amendment process typically begins with an EA or an EIS filing. It then follows a quasi-judicial or contested case hearing process in which parties provide their exhibits and witnesses, present their cases, and are subject to cross-examination before a findings of fact are prepared and a decision rendered. The LUC has 1 year in which to make a decision. Currently, about 95% of the lands in the state are in the agricultural and conservation districts. The urban district still comprises just less than 5% of all lands in the state. Here's a statewide map showing the land use districts for each island. Oahu has the most urban lands, approximately 104,000 acres, or about 27% of Oahu, which is in the urban district. Maps of individual counties are available at the Public Review Draft Report website. In 2014, the Office of Planning convened a task force of agencies and organizations with interest and experience in the state land use process. Here are the organizations that were asked to participate in the review. 8 meetings were held over the past year to discuss issues and opportunities to improve the land use process. From November 2014 to March 2015, the Office of Planning conducted community and stakeholder meetings to broaden its outreach to the public. We asked participants about their experiences with the land use system and to share their ideas on how to improve the system. OP compiled and assessed all of the comments received into a public review draft report that is now available for public review and comment. The report provides background on the land use system, analyzes the various issues and problems that have been raised, and presents proposed improvements that have emerged from the review process. We'd now like to invite the public to review this draft report and provide us with comments that can be considered in finalizing the report. The public review draft is available on OP's website. Comments can be submitted in one of 3 ways: digitally on the website, by email to the email address seen on your screen, and by regular mail to the Office of Planning at the address that is also shown on the screen. Comments on the public review draft are due by May 31st, and all comments received will be considered as OP prepares its final report. The final report is expected to be completed by July 2015. Mahalo for your time. We hope you will review the report, and we look forward to receiving your comments.
Okay, hi. My name is Will Spence. I'm the Planning Director for Maui County. One of my concerns as being director has been the ability for the county as well as the state to be able to make accommodations for housing. I know that Maui County is currently undergoing a shortage. I understand that that the state is too. I note this article from the Advertiser on the 7th of this month, and it notes the need for housing in the next 10 years. And Maui County in particular, we're going to need 14,000 additional units. My concern with our state land use regulations is the cumbersome process and the amount of time that it takes to get entitlements for builders to be able to build units for our community. The estimates are that the entitlement process takes between 7 and 10 years, and I find as director, following the process all the way through from the EIS to the Land Use Commission to the time it reaches our Planning Commission to the time it reaches County Council, the processes can be quite redundant. You know, the same information is presented over and over again to different approval bodies, and that takes an inordinate amount of time. It takes an inordinate amount of money, and those costs and that time is passed on to the residents that are going to live in those units. My hope is that as we look at our laws, we really sit down and decide, okay, this part of this process is not working. This is something that we can do. Instead of doing the same thing over and over again and taking this time and this money, let's look at something without sacrificing environmental protections. I think that's extraordinarily important, and that's something that we, as a state, we need to maintain. But simplifying the process so we can go ahead and provide housing for our residents. As government, we have, in providing housing, there's really 4 major factors. One is the entitlement process. Another is materials, mostly that we import. Labor is relatively fixed. And financing, that's sort of an unknown because the process takes so long. Things may entirely change from the time a project is planned to the time that it's actually funded for construction. But as government, we have the ability to change the entitlement process. That's the one thing that we can directly control and directly influence through legislation and aid with the, towards providing housing for the islands.
What we need is clear criteria to guide our land use decisions so that they don't appear to be arbitrary or inconsistent. Also, it would be good that instead of looking at projects on a case-by-case basis, if we look at the broader picture. So, for example, one way we can do this is to look at our state and county plans. Because that's the purpose of our plans, to guide development. If there's a certain area that we want to preserve, or a certain area where growth may be appropriate, we do this in our state and county plans. At the statewide level, we actually do have a statewide plan. It's the Hawaii Statewide Planning Act. Unfortunately, this plan was last updated, at least comprehensively, in 1985. So it is 30 years old and needs to be updated. On the other hand, all of the counties have land use plans, which are fairly up to date and fairly specific in specifying where growth can occur and which areas should be protected. And that's one reason why the American Planning Association supports transferring the responsibility of reclassifying lands from the state to the counties, or at least changing the process to give more weight to the county plans. People should care about the land use system because it affects everyone, both positively and negatively. Think about what makes Hawaii special and all the land uses that we have in our communities. We have our beaches and our mauka areas, our streams, valleys. Those are, for the most part, in the conservation district. Also, you have agricultural lands, which of course are for crop production, farming, and agricultural ventures. Then we have our urban lands, where most of our homes, restaurants, shops, and employment is located. A good land use system and good communities find a way to balance these land uses. If the land use system doesn't work as it should, we have problems. For example, if we're too development oriented, we lose agricultural lands or valuable open space. On the other hand, if we don't provide enough urban lands, we end up with housing shortages, high housing prices, or businesses don't have room to grow and expand. So people should care because it affects everyone in some way.
Aloha, my name's Lucienne Diné, and it's been my honor for the last year or so to serve on a panel reviewing the State Land Use Commission. I've served with a broad range of people. I served representing the Sierra Club Hawaii chapter, but I took my responsibility to mean a much broader constituency, including all of you watching here at home. I live on a small subsistence farm in Maui, and I was the only neighbor island person who was a regular citizen who attended this focus group on what we could do to improve our land use process through the Land Use Commission. We heard a lot of interesting ideas, and it all boiled down to a couple of things. One, are we ready to switch to more county review and less state review of land use? And two, if we have state review, should it be a quasi-judicial or legislative sort of process? Well, this may not mean a lot to you guys at home, but let me just frame it in this way for you. Why should you care? There's going to be a draft plan introduced for public comment, and I hope you will comment. I happen to believe that our system is working. Yes, we do have some projects that are held out because they are challenged by interveners, but I think that that is something that's healthy in a democracy. Yes, we are duplicating processes to some extent, but every healthy system has redundancy in it. If you look at a space shuttle or if you look at nature, they all have a plan B. In case review one is not really getting at all of the important things about a project, review two can serve as that function. And the Land Use Commission has a mission of protecting our public assets. You are the public that are going to benefit from that. If someone's proposing a development across the street from you, you have two choices. If it goes to the Land Use Commission under our current system, you have a place at the table. You and your neighbors can intervene, you can present all of your facts. Otherwise, your option is a 1 or 2 minute testimony at the county council. End of story. You don't present anything, your story is not heard. So please, as this plan is presented for review for the State Land Use Commission, come out and let your voice be heard. We need the state and the county to both participate in this process in order for you to have a voice, in order for your resources to get the level of review that they really deserve under our Constitution and under our state laws. Thank you so much for caring about all of our resources and our people in this beautiful state. Aloha.